Thank you, and welcome everybody to episode 12 of 20 Minute Talks. This month we have Kevin O'Brien. So thank you for joining us, Kevin. Kevin O'Brien was called to the Quebec bar in 2003. Since then, Kevin has practiced law in various highly reputed national and provincial law firms in Montreal. Many of you may recall David Franklin, a mainstay of CCAA conferences. Through a common friend, David, then looking to retire, approached Kevin to acquire his firm in 2020 after a distinguished career spanning several decades. Very early in his discussions with David, Kevin concluded that David is not only a wonderful person and a gentleman, but also that David's business and professional model is unique in the Canadian marketplace, and that the firm offers turnkey creditors' rights legal services on a contingent fee model in almost every country and city on earth. The whole with an industry-leading track record of successful collections. So in February 2021, Kevin O'Brien acquired David Franklin's law firm and merged it into his then and current practice, which specializes in general commercial and transactional law. The resulting firm is called Franklin and O'Brien Legal Services. Since then, Kevin and his team continue to try and honor David's legacy in the industry by offering highly attentive and professional creditors' rights services to its clients, many of whom are members of CCAA. Welcome, Kevin. Thank you very much, and we're looking forward to your presentation.
Oh, good. Thanks a lot, Annette and Humberto, for thinking of me, and thanks to all of you for letting me drone on today about the mind-blowing subject of Canadian contractual law during an already busy holiday season. So today we're going to look at some of the challenges we run into when pursuing debts in Canada for our American and international clients. Of course, we could do 10 sessions like this and still not cover everything, but let's start with this. Like in the United States, the provinces and territories of Canada are all empowered under our Constitution to regulate trade and commerce within their borders. So each province has its own legal framework for commerce. For added complexity, though, 9 out of 10 provinces and all 3 northern territories adhere to the British common law tradition, which means that in the absence of a statute or a law dealing with a particular subject matter, attorneys and courts will turn to precedent law or jurisprudence to determine the state of the law on a particular subject. On the other hand, in Quebec, which is the black sheep of Canada and the primary focus of this presentation, the legal system was founded on the French legal tradition, which is broadly based on the Napoleonic Code. Put simply, Quebec's legal framework is largely codified in the Quebec Civil Code, a collection of more than 3,000 riveting articles covering an endless range of subjects, including contracts, which, as you all know, are the foundation of all commercial activity and, by extension, any commercial debt collection case. So now we're going to look at some of the types of contracts that you and I run into every day in our practice. Article 1378 of the Civil Code establishes the nature of the various contracts that exist in Quebec, which will in turn dictate the legal framework for each sort of contract. That legal framework includes certain rules, conditions, and legal presumptions that will guide the courts as they consider questions surrounding the formation, application, interpretation, and enforcement of contracts. Bear with me 1 second. I'm just going to put this here. In some cases, the nature of the contract will also determine whether the contract will be subject to other laws or statutes. For example, in Quebec, the Consumer Protection Act and its regulations apply to all consumer contracts. That law, which is of public order, which means it can't really be contracted out of, contains several requirements pertaining to the form, content, application, and enforcement of consumer contracts, along with several other legal protections in favor of consumers. Consumer contracts are also subject to Quebec's French language laws, which provide, among other things, that all consumer contracts must be drafted in French at the risk of being declared null and void. All that means that, similarly, I guess, to the United States, B2C debts are more complex and tedious to collect in Quebec than B2B commercial debts, for sure. But even then, the Civil Code developed a category of non-consumer commercial contracts called contracts of adhesion. A contract of adhesion is a contract where the essential provisions of the agreement are deemed to be imposed upon one party, usually your debtor, by another party, usually your creditor. Basically, these are agreements where the bulk of the terms, conditions, and obligations are deemed not to have been freely negotiable by the by the debtor. Put simply, many credit applications, bills of lading, product purchase and lease agreements, service contracts, even software licenses, and so on, are frequently deemed by the courts to be contracts of adhesion. Rule of thumb, if your contract contains large sections that are drafted in small font or laid out in 2 or 3 columns, or if you're reading them online or on a templated, unchangeable format, you are likely reading a contract of adhesion under Quebec law. So what's the significance of that, you ask? Well, contracts of adhesion, even between 2 companies doing private-to-private business with one another, are also subject to certain more onerous rules, restrictions, conditions, and legal presumptions under our civil code, which would not apply to negotiable contracts, and which you can take for granted are designed to protect the adhering party, in other words, your debtor. Furthermore, more recently in 2023, the Quebec government, running a bit low on political capital, turned up the nationalist linguistic rhetoric in the province and enacted some major revisions to Quebec's French language laws. Among them was the creation of a new obligation that all contracts of adhesion, even between businesses, must be drafted first and foremost in French. I repeat that because it's significant. All contracts of adhesion must be drafted first and foremost in French. This means that the party sending a contract of adhesion, even if that company is based in the United States or elsewhere, to a customer in Quebec, must provide that customer a French version of the contract at the outset of the transaction. The parties may then make a mutual election in writing to sign an agreement, sign an English translation of that French contract. But the takeaway and the central obligation here is to first and foremost provide the adhering party a French version of the contract. Needless to say, you guys are the only people outside of Quebec that know about this law now. So very few contracts of adhesion that come across our desk here are drafted in French. But I thought it was important to mention it because failing to comply with these obligations can result in nullity of your commercial contract and even penalties in some instances, such as for repeat offenders that are subject to complaints. Now we'll look at personal guarantees and some of the pitfalls we see when we're dealing with personal guarantees. Once again, each province has its own legal requirements as to the form, content, and conditions for validity and enforceability of a personal guarantee. For instance, in some provinces, a personal guarantee must be notarized or must be signed in front of a lawyer who must explain the legal implications of the guarantee to the guarantor. The overarching objective in most cases is just to ensure that the guarantor's consent was clear and enlightened upon signature. Similarly, in Quebec, the Civil Code provides that a personal guarantee must be explicit, unequivocal, and clear as to the intention and scope of the guarantor's obligations. The case law in Quebec is spattered with plenty of court rulings where creditors have fallen short of legal requirements in respect of a personal guarantee and therefore failed to prove their validity and enforceability. Many such failures have arisen due to seemingly innocuous formalities, such as failure to provide a distinct signature line for the guarantor. to distinguish him or her from the person signing on behalf of the principal debtor, which, as you know, is often the same person anyway. Another interesting, lesser known problem we come across with personal guarantees in Quebec is that the Civil Code provides that a guarantor has the right to unilaterally terminate the guarantee after 3 years if the underlying debt has not been fully crystallized. Another issue we see in the Civil Code is that unless the guarantor has explicitly waived the benefits of division and discussion, the creditor is required to exhaust its claims and recourses against the principal debtor first before it could turn its attention to the guarantor for payment of the debt or whatever is left of it. So now we're going to look at service contracts because we come across these quite a bit. So Article 2098 of the Civil Code defines service contracts as follows. A contract of enterprise or for services is a contract by which a person, comma, the contractor or the provider of services, comma, as the case may be, comma, undertakes to another person, comma, the client, comma, to carry out physical or intellectual work, comma, or to supply a service, comma, for a price, comma, which the client binds himself to pay. I'm exaggerating, but after tripping over all that punctuation in a run-on sentence, my first observation is that the legislators could have done a bit more effort into translating that provision into English so sane people could understand it. That being said, the important takeaway here is that under Quebec law, service contracts encompass a wide range of commercial agreements that you've all come across at some point. From actual physical services, such as transportation, snow removal, management, consulting, even debt collection services. But you could also include under this definition agreements for online marketing, accounting platforms, cloud-based data management and storage, point of sale services for retailers, and in some cases, even software license agreements or parts of them may be construed as service contracts under Quebec law. Why is that significant? Because very few people outside of Quebec are aware that under Quebec law, a service contract may be terminated unilaterally by the customer at any time and for any reason upon simple written notice of termination to the service provider. I'll repeat that. A service contract can be terminated at any time by the customer for any reason. This right applies even when the parties took care to include a specific term for the contract, such as 3 years with automatic renewals. And if the contract is terminated by the customer, even before the term lapses, the service provider, our creditor and client most times, is only entitled to recover amounts set out in the contract up to and including the termination date. It is possible for the parties to contract out of this ridiculous unilateral termination right for the customer, but to do so, the contract needs to contain an explicit and unequivocal waiver by the customer of the application of its codified right to terminate, taking care to mention the specific article of the Civil Code which allows for it. Needless to say, in more than 20 years of practice, I can recall reading a grand total of one service contract drafted outside Quebec, which contains a valid and enforceable waiver of the customer's unilateral termination right. Nevertheless, failure to include such a clause in your service contracts means that your debt claim may be largely uncollectible if the debtor can demonstrate that it delivered to the creditor a written termination notice, even by email, at some point during the term of the agreement. So now we'll look at what we call here external clauses. They are those online terms and conditions which you guys have all seen, these hyperlinks in the small print of a contract. You know, there's a blue font link that when you click it, it leads you to online terms and conditions. As I mentioned, those are commonly called external clauses or incorporations by reference in Canada. These are popular in bills of lading, product order forms, software licenses, online service contracts, and many other contracts. Sometimes these links bring the parties to terms and conditions that are remarkably important provisions, particularly for debt collectors, such as provisions requiring debtors to pay interest on overdue amounts, or legal fees and collection costs, and the always popular venue and law clauses. So are those external clauses found online behind those little blue hyperlinks valid and enforceable against debtors in Canada? Well, the short answer is maybe. Again, each province has its own rules for external clauses, but in most provinces, the overarching question is whether those provisions were known or not to the adhering party, usually your debtor. Which is to say, were they brought to the person's attention and agreed to when signing the primary contract? This, of course, will need to be proven when it counts most, which you can imagine is not always easy. In Quebec, Article 1435 of our Civil Code codified these principles by providing that external clauses are deemed to be valid and enforceable, wait for it, except that for consumer contracts or contracts of adhesion, they are deemed to be null and void unless at the time of signature they were brought to the attention of the consumer or adhering party. Again, not easy to prove when it counts. So I guess the takeaway here is that if you wish to enforce and rely upon external clauses, which is likely why they were posted on your webpage, it's probably best to have the adhering party confirm their agreement to be bound by them, for example, by putting an initial box next to the link to the external clauses or the online clauses, or even better, by adding a line somewhere around the signature box that said that the debtor read, understood, and agreed the online T's and C's, and having them sign next to it or initial. Failure to do so may well result in the court setting aside those provisions as invalid or unenforceable in some jurisdictions. Finally, on this topic, much like interest provisions, penalties, and collection costs that we sometimes see at the bottom of invoices, links to external clauses contained in an invoice are not typically valid or enforceable against a debtor in Quebec, because an invoice is not considered a contract. So to conclude the presentation, I wanted to take a moment to discuss one of the more recurrent problems we deal with in our debt collection practice, the famous choice of venue and law clauses. Are there any provisions in a contract that seem more like self-sabotage for creditors than these exclusive venue clauses? And the more restrictive these clauses are drafted, the more self-inflicted heartburn they seem to cause the creditors that insisted on them in the first place. And for legal practitioners like me, the issue is that once I see the clause, I just can't unsee it. That said, when I get a case where there's a written contract, one of the first things I look to is the venue and law clause. Now, while it's probably not great as a business strategy for me to turn away work when the venue clause is pointing the parties to a venue outside of Canada for their disputes, which is more than half the time, I do try to bring these clauses to the client's attention early on because they truly can be impactful for the commercial claim. The main concern I run into with these clauses is that if the client opts out of a clear venue clause in their own contract and instructs us to take action against the debtor here in Canada, example, because the debtor is located here or we know they have assets here, and if the debtor invokes the venue clause in the plaintiff's contract, the courts here have a broad discretion to decline jurisdiction and dismiss the action with costs against the plaintiff. In turn, the creditor will now have to turn around and start a new lawsuit where their venue clause requires. And then, once they have a judgment, They have to come back to Canada to have the judgment domesticated so that they can ultimately enforce on the debtor's assets. All of this creates more costs and delays. And the other thing we have to keep in mind is the statutes of limitations. Here in Canada, the statute of limitations for commercial debt claims is again regulated by each province. Most provinces have elected to have 2-year statutes of limitations. Quebec has three-year limitation periods. So the concern is that by the time the court dismisses an action here by declining jurisdiction due to the venue clause, the client may be time barred in the other jurisdiction where the venue clause is pointing. This very situation happened to us recently when, against our recommendation, the client instructed us to issue suit in Quebec, where the debtor was located and where there is a 3-year limitation period. The debtor then invoked an Ontario venue clause in the creditor's own contract, and we had to hastily discontinue the action in Quebec to turn around and sue the debtor in Ontario inside their 2-year limitation period. So in conclusion, we've covered only a few of the recurring pitfalls that we run into every day in attempting to collect receivables here in Canada for our American clients and colleagues. These challenges, along with a more complex, not to say cumbersome legal system, can make debt collection cases a little bit more difficult and costly in Canada than in the United States. But the good news is my firm's here to assist you anywhere in Canada and worldwide. And if there's any questions or anything else you'd like to comment about my nonsense today, let me know.
Kevin, thank you. I have a question. You mentioned that the laws differ between provinces regarding personal guarantees.
Yeah.
Is there a universal, or does it change if personal guarantees can be embedded into the credit applications? We've seen that stateside where it differs, some and that they can or cannot. Do the provinces do they speak to whether they can be part and parcel of the credit app, or do they say that they have to be a separate document?
So in Quebec, the answer to that is there's not a specific formality that I know of in each province that requires the contract to be freestanding. I could look this up. I didn't do the exercise of each province, but what is significant is that the contract, the personal guarantee needs to be at least freestanding enough that the guarantor is distinguishable from the main primary debtor. And as I said earlier, usually it's the same people signing sometimes. So in Quebec, for example, if you just jab it into the bottom of the signature box of a contract and you're not careful, you'll run the risk of someone saying, well, no, we didn't sign a personal guarantee. He was signing on behalf of the debtor as this or that. I think in Alberta, actually, the personal guarantee does need to be freestanding, but I'd have to double check.
I have a question as far as personal guarantees, Kevin. You said that in order for us to go after a personal guarantor, you have to exhaust the efforts to collect against the primary debtor.
Mm-hmm.
How is the determination made as far as how efforts are exhausted? How far do you have to go?
So I'll be honest with you. Anyone that's doing anyone that's doing business inside Quebec is aware of this a lot, or if they're counseled anyway, they're aware of this. So we can contract out of that stuff, and so a lot of times clauses will contain provisions which you guys will refer to as joint and several. We'll refer to in Quebec as solidary responsibilities, and we'll carve out those benefits of division and discussion, which are which are the benefits that I'm referring to, that say that the guarantor is entitled to have the claim go the distance against the primary debtor, and that's that's what the implications are. Is you've got to have exhausted your efforts. That could go all the way to the end of court against your debtor. Typically, what will happen though is you will put both the primary debtor and the guarantor in the same action, but the court, if there isn't been a waiver of division or discussion, the courts will carry on through the whole procedure with the debtor, and at the end may make a determination to have the guarantor also held liable to the extent that the debtor doesn't pay the obligations. Like, we won't hold back from putting them both in there, even if we don't have the clause. But ultimately, the courts will if the benefit of division and discussion means that the courts will wait to see if the primary debt is, first of all, if it's claimable. Second of all, if the primary debtor pays the debt and fulfills its obligations before they'll enforce it against the guarantor.
And then
I have a question. Oh, go ahead.
go ahead. No, go ahead, Annette.
There's a question about licensing in the United States. There are different states that require either a license and or a bond and or a certificate of authority. Can you speak to the licensing that is required in Canada? That's one of our questions.
Licensing for what exactly?
For debt collection?
Yeah, that's another subject I haven't really scoured, but again, because each province has their own stuff, their own laws in respect to commerce. I think it's a province by province thing. I believe, I may be wrong here, but I believe you would be required to have a license in any of the provinces that you intend to exercise debt collection work in. Now, the question then becomes: do you need to have a physical office in that province in order to actually be considered to be doing a commercial debt collection in that province? I tend to be of the view in these things that sometimes it's better to ask for forgiveness than ask for permission. Do the work you do, and then if you get notified, adjust quickly. Because I think it's quite a process to get these licenses in every province, especially if you're not going to hold offices physically in those provinces.
Thank you. Anybody else have any questions?
Yeah, I have another question. So, Kevin, I see a lot of clients where the financial amount is not distinguished between US dollars and Canadian dollars. It's just there. Now, a lot of these clients are here in the United States, and the assumption is US dollars, but it doesn't specifically state that. Is there an issue if you now have to sue in Canada?
So the courts will want to know the Canadian equivalence of whatever that claim is. So if you're saying it's undistinguishable, we sort of run with the presumption that if the creditor is located in the United States and our client, the collection agency, is located in the United States, and if there's no mention of our provincial and federal sales taxes at the bottom of those invoices, we basically sort of figure that 99% that's US dollar, that's a US dollar claim, and we'll treat it as a US dollar claim right until the point where we're going to court. And we may even allege in the allegations the US dollar amount. And at the very end, though, we'll have to do a conversion in time because the court has to render a decision that the Canadian debtor can pay in Canadian dollars. So it'll probably crystallize at the point of judgment where we'll say, well, on the date the judgment's rendered, or we'll give a little bit of a window. This is the dollar amount in Canadian dollars, and then we're able to remit back in US dollars for you guys, but there will have to be a conversion at one point if we're going through the court system.
Anybody have any questions? Okay. Kevin, this has been really great. It's really good information. We really appreciate you being here. It's definitely a broader viewpoint to go international now, as opposed to going state by state. So thank you very much for enlightening us.
Ah, great. It was fun.
We appreciate the education. Annette, I think you had some announcements.
Sure. For the new year in 2026, CCA of A is inviting all of its members, and those is everybody on this call, and if you're not, then we ask you to join CCA of A. But if you're already a member and you would like to participate in a committee, we are going to reconstitute some of our committees because we're going into a new year. So we have education, we have finance, we have membership, we have events, we have vendors, we have legislation, and we have future leaders and collection. So if anybody is interested in joining a committee, let me know. Just email me. I'll put my email in the chat. Also, we are scheduled through May for our next 20-minute talk. So we will be meeting every month. The next meeting will be January 22nd. Jeff Rubin from Talanoff, Rubin and Rubin in Florida will be our next speaker. And we are scheduling. So if you have any speakers that you would like to recommend, we can schedule them for the second half of the year. So make sure to mark down. You'll get an email. The next 20-minute talk, TMT, is January 22nd. I want to wish everybody very happy holidays. I want to thank Kevin and thank Umberto and congratulate Umberto again on a wonderful 2 years. And I think this is just a wonderful platform and a very effective platform to reach the CCA of A members. So congratulations, Umberto, in doing this. It's wonderful. And happy holidays to everybody. And thank you for joining us.
All right. Thank you, everybody.
Bye-bye.
Happy
Thanks.
holidays.
Thank you.
Have a happy new year.
Happy holidays.
Thank you.
Thank
Thanks,
you.
Kevin.
Thanks again, Kevin.